Let me see if I understand what we're doing here. You have just said to me that I'm appearing pro se, and all of my paperwork tells you plainly that I'm appearing in propria persona. Now, how you jump to the conclusion that I'm appearing pro se is beyond me. Let the record show I am not here pro se. And if that isn't plain enough, I don't know how much plainer I can make it. Every paper I've filed says specifically George Gordon in propria persona. Definitions I will leave to the court's discretion. You can look them up as well as I can. Now, if we're going to decide, first of all, the administrative and procedural matters, which is a matter of due process, then I'm perfectly willing to let you tell me how to proceed. But it was my understanding that you told me to decide how we wanted to proceed with the administrative and procedural matters, and it was for that reason that I chose the order.
Mr. Gordon, I'm getting the impression that you're trying to delay and confuse the court. You may be delaying, but you're not confusing. The issue here at this moment is counsel. Now, do you wish to proceed on that matter, or do you not?
I only want to talk about the subject matter of counsel as it relates to the administrative and procedural matters. I'm not prepared to argue the counsel issue as a matter or a subject matter of this hearing. We're not in the hearing yet. Now, are you going to deny me this due process of the administration and procedural matters and just assume or presume jurisdiction? Because I'm contending this court doesn't have the jurisdiction to listen to this motion hearing. And therefore, until we get to the subject of jurisdiction, how can we sit here and discuss the subject matter of the motion hearing? We don't know whether or not this court has jurisdiction or not, and I've challenged the jurisdiction of this court.
Well, Mr. Cook, it appears to me that you've raised a sort of a chicken and egg proposition here. Somebody must decide which comes first, and I have decided that counsel comes first. So you may proceed on the issue of counsel. Then you can take up your administrative and procedural matters, and then we'll proceed from there.
All right, now I think I understand. We are no longer in administrative and procedural matters. Is that what the court is telling me?
The issue here right now is whether you are going to be represented by licensed or unlicensed counsel.
Okay, I can answer the court's question. Absolutely not.
Absolutely not what?
I am not going to be represented by licensed counsel, and I'm not going to be represented by unlicensed counsel. I'm representing myself, and I'm representing myself in propria persona.
Very well. Now that issue's out of the way, let's go on with the administrative and procedural matters.
Thank you very much, Your Honor. Now we have to attack the issue of jurisdiction. And before I can argue the issue of jurisdiction, I must have the assistance of my next friend, Mr. Clyde Jones.
No objection, Your Honor. Is that man licensed?
No, he's not. Mr. Jones is not licensed?
No, the state of Idaho.
The issue has already been decided.
All right, now, let me see if we understand our positions here before we move any further. Before we can argue jurisdiction of the court, this court then has on the record denied me counsel of my choice to assist me in arguing this procedural matter.
You're putting words in the mouth of the court. The court has not denied you counsel of your choice, but the court has denied you unlicensed counsel. Now, you may have any counsel you want as long as he's licensed.
Are you speaking then in this frame of mind? Are you saying that I can have a licensed lawyer, if he's licensed in the state of Idaho, he can come in and assist me or represent me? Is that your position, Your Honor?
That is the position of the court.
And does that seem to be the position of the state?
That's the position of the state, Your Honor. The state has no objection to licensed counsel.
Then the issue is settled.
Okay.
Proceed.
I just want to know from my own understanding and for the record, so that when the issue is moved into the appellate courts, that there's no misunderstanding. I'm claiming here the absolute right to unfettered counsel.
Mr. Cook, that issue has been decided. Now, if you wish to proceed with something else, you may do so.
I want to proceed. Excuse me, Your Honor.
Otherwise, I may have to hold you in contempt for delaying the court.
Are we ready to move forward on jurisdiction?
the court is ready to move forward. I'm not sure about Mr. Cook, but you may proceed.
All right. Now, I am not prepared to move forward on jurisdiction unless or until I have a judicial determination on the record that this court is absolutely denying my counsel of choice pursuant to the jurisdiction question.
Well, for one last time, Mr. Cook, let's make it very clear. This court is denying you counsel of choice if you want unlicensed counsel. Otherwise, you may have any counsel you wish.
Thank you, Your Honor. It's that admission and confession on the record that I needed. Now I'm prepared to bring up the last subject of the big three in pursuance of administrative and procedural matters, and that's the question of jurisdiction. Now, I've challenged the jurisdiction of the court, and I'm claiming that I'm not a licensed driver, so therefore, without license, without registration, and without insurance, this court has no jurisdiction in this matter and cannot proceed. It cannot proceed for these reasons. One, there is no money pursuant to Article 1, Section 10, and the court lacks total capacity to effect a remedy. Two, the court has on its own volition denied me counsel, so therefore, Argersinger versus Hamlin Sheriff comes into play, and this court has precluded the possibility that it can now incarcerate me. So now that you cannot incarcerate me, and since there is no lawful money, and Idaho Code specifically calls money and money of account of the United States and dollars the only substance for which you can administer fines, this court has no jurisdiction because it cannot effect a remedy. Second, the court has no jurisdiction over a free man who comes into the courtroom and says plainly and stipulates on the record that I have no driver's license, the car I was operating was not registered, and there is no insurance, and therefore the police powers of the state fail in this instance. Now, there's one last item that I think the court should be aware of, that if the court proceeds against me, over my objection, against my will, and denies me rights secured by the constitutions of both Idaho and the state, and the federal government, we're entering into a realm then of deprivation of rights, which comes under the federal statutes, Title 42, Section 1983. And I would contend at this time that the court should determine the question of jurisdiction and either presume or assume jurisdiction and then give me a judicial determination, and then we'll be ready to move forward into the motion hearing.
Well, Mr. Cook, as far as jurisdiction, this court has jurisdiction. Your crime was committed within the district in which this court is located, so that gives this court jurisdiction on that count. As far as the ability to effect a remedy, the court doesn't care what you pay your fine with. If you are convicted, you can pay with anything you wish. The state will accept it. And you were traveling on the highways, and if you would travel on the highways, that doesn't make any difference to the court whether you were doing so legally or illegally, but you didn't have registration, you didn't have proof of insurance, and those are crimes in the state of Idaho. So this court does have jurisdiction.
All right, now, is the court presuming jurisdiction or assuming jurisdiction? For the record.
The court is assuming jurisdiction.
Thank you, Your Honor. The defendant is now ready to move forward with the motion hearing.
Proceed.
Thank you, Your Honor. Since the counsel issue has been decided in the administrative and procedural matters and is now a closed subject, it is the position of the defendant that this case must be moved into the appellate stage before the defendant can move forward. The court has assumed jurisdiction, and therefore, pursuant to Rule 54.6, a substantial right of this defendant has been violated. Pursuant to Argersinger versus Hamlin, Gideon versus Rainwright, Burgett versus Texas, Chandler versus Freetag, I think at this time, Your Honor, I'll move for a suspension of the motion hearing pending appeal on the issue of counsel and jurisdiction to the District Court of the State of Idaho.
You know full well, Mr. Cook, that all appeals must be taken after final judgment, so your motion is denied.
Well, Your Honor, then I'm not prepared to move forward without counsel. And I demand my absolute and unfettered right to counsel of my choice. And at that point,
that issue has been settled.
I understand that, and I want to appeal that to the Federal
All right,
Supreme
you may
Court.
appeal. You may appeal.
Fine.
You go after final judgment.
Are you going to?
When you're convicted, you may appeal.
I'm going to file the appeal in the morning, Your Honor, with the district court. So as far as I'm concerned, today's motion hearing can be terminated.
Very well. This motion hearing is at an end.
Thank you, Your Honor. Well, I don't know how we're going to score or grade that fellow, but I'll leave that up to you, and I want to show you the technical points of what we've just covered. The points that were covered were administrative and procedural matters prior to moving forward with the official part of the hearing. Remember, when you say, I'm ready to move forward, the hearing gets underway. Before the hearing gets underway, the administrative and procedural matters, and there could be a dozen of them. It's hard to tell just how many you're going to have. I'll read off a couple of three of them for you here in a moment if I have time. Let's see if I've got some. No, I don't have them right here in front of me, but let me show you what we did there. Pursuant to the rules of procedure, if you'll take out your rules of procedure and look at Rule 2.2, you've walked into this court. This is your very first hearing. And at your very first hearing, you must challenge the jurisdiction of this judge, or within 5 days of learning or of official notification of this judge, if you have some objection, then you've got to disqualify him. So in this case, I walked into the courtroom and said, well, I don't have any problem with the trial judge per se. What I want to determine under Rule 2.2 is whether or not he's been approved by our state Supreme Court and the district court judges. Well, the man said, yeah, I'm an attorney magistrate, and I've been approved, and that's the end of the argument. But what if he doesn't know? You know, I've asked that question of 3 or 4 judges, and not a one of them knew whether or not they'd been voted on, and a couple of times judges do not have the capacity or the power to incarcerate you. And if they don't have that power, then they can't proceed against you, and you should disqualify them because of the lack of their capacity. Now, in this particular judge's case, did you notice that I said on the record, I reserve the right to appealable error if we find later that you have not been approved by the district or the Supreme Court judges. And if you'll look at the bottom of the page, Rule 2.2 says, failure to demand that right waives it. Now you say, well, why did you bring that up before counsel, or why are we even talking about administrative and procedural matters? Well, here's why. The moment I say, yes, I'm ready to move forward, I have just accepted that judge, and now I can't object. If you'll look at the bottom of Rule 2.2, down toward the footnotes, it says, failure to object timely waives this objection. Well, I don't want to waive any rights. You know, one of the first things you want to say in the hearing is, I demand all of my rights at all times and waive none of my rights at any time, including my right to time. You want words like rights and demand, not I think or I request or if it please the court. Because if it pleases the court and it doesn't please the court and the judge says, no, it doesn't please me, no, you haven't made a demand. You've made a request and somebody said no. It's like your kid coming to you and saying, can I have a dime for an ice cream? And you say no. You can see when the last time I bought an ice cream was. All right, now the second subject matter that had to come up in administrative and procedural matters was counsel. Why not jurisdiction? Well, if I were to sit here and argue the jurisdiction issue, then it's obvious that I don't need counsel to argue the jurisdiction issue. So after I've completed arguing jurisdiction, then when I say, well, now I need counsel, the judge sits there and says, what for? You've been acting pro se, you've been doing a fine job, I don't see any need for counsel. And the courts are going to look at that and say, wait a minute. This guy obviously doesn't need counsel, he didn't demand it timely. The judge is trying to steamroller me into saying, let's go forward into the motion hearing so that you can waive those demands for challenge to the judge, jurisdiction, and counsel. Once the hearing opens, now we've got another ballgame. We've already accepted the jurisdiction of this trial court judge to hear the motion hearing. If you'll notice, I terminated this as soon as he assumed jurisdiction. Not just presume. I'm presuming that I have it. I don't really know. I think I've got it, and I don't want to step on your right. This judge says, we're assuming jurisdiction, dummy, whether you like it or not. We are going to proceed against you. If you'll notice, I told him that we could be entering into an area of civil rights violations here. The judge is now sitting behind the bench, and he's no longer ignorant. You have a belligerent claimant. The belligerent claimant is in person. He's in person demanding his rights, and more specifically his right to counsel, and he is documenting his demands with Supreme Court cases and documentation. In addition to that, under the subject of jurisdiction, the defendant said this court doesn't have jurisdiction, and that defendant told the court plainly why it didn't have jurisdiction. Now the court is without excuse. The court has been read its rights. The court has been told, you had better go seek some legal advice or counsel or decide or determine whether or not you've even got jurisdiction to move forward. It's absolutely impossible for me now to move forward and argue this motion hearing at this time, because I can't have counsel. Cannot. The judge was emphatic. He said, you've been denied counsel. I couldn't have made an admission or a confession better myself if I had written it out and said, Judge, would you sign this? I doubt very seriously that you're ever going to find a judge look you in the eyeball as Judge Curtis just did and say, you've been denied counsel. That's the winning issue. This case is already won. There isn't anything in the world that can occur now that would preclude victory from my camp. Now, the reason I terminated this motion hearing and the reason the judge wanted to move me forward, if I had said, well, okay, I'm going to go ahead and argue the motions, I would have been waiving my jurisdiction and counsel issues. If I'm going to sit here and argue right sua sponte in a 12-man jury and the procedures that I want the court to follow, well, then it's obvious that this judge over here must have the capacity to hear and decide the motions, because if he doesn't have the capacity to hear and decide the motions, why am I even telling him about them? Think about that for a moment. Here you are at the dining room table and you're having dinner and you're telling the wife or the hubby and you're talking over dessert here. Well, I was in court today and boy did I lay that judge low. I said he didn't have jurisdiction over me. And then what happened? Well, he overruled my presumption or my position. And then what'd you do? Well, then I went on to argue the right sua sponte and the procedural matters and a whole bunch of motions. And then how did he rule on those? Well, he granted me 2 and overruled 6. Or what are you going to do about the jurisdiction and the counsel issue? Gee. You see where you are? Now watch what I did to this judge. I shut him right off. I pulled 3 rails out of the roadbed and the train hit him. Train's off the track. My contention is, number 1, I've got to have counsel to help me argue the jurisdiction issue. The judge says, no, can't have it. End of argument. Well, then it's obvious I can't argue the jurisdiction issue competently because I don't have counsel. That's my position. And until we have resolved the counsel issue and its relationship to arguing jurisdiction, I can't go to trial. I can't even finish the motion hearing. I'm going to appeal this lower court decision to the district court. The district court's going to say the judgment of the lower court affirmed. Then I'll go to my state appellate court. The judgment of the district court affirmed. Then I'll appeal it to the state supreme court. The judgment of the appellate court affirmed. Then I get my opportunity to argue this case to the Supreme Court of the United States 2 years from now. And the Supreme Court of the United States is going to take judicial notice of what? My argument at the motion hearing. I can't move forward here. This court has no jurisdiction and out of its own mouth denied me counsel of my choice. In violation, gentlemen, of your decisions in times past. And they did so with the full knowledge that they were doing so in violation of this high court's ruling. The high court's going to make a ruling. I would suppose that they'll rule in my favor and remand the issue back to the magistrate's court, ordering this court to allow me to have counsel of my choice. I will then come back into Judge Curtis's court with counsel of my choice, an order from the Supreme Court of the United States, and I will then say, now, Judge, we are ready to move forward to argue the third leg of the administrative and procedural matters. My counsel will now assist me and present the jurisdiction argument to the court. How do you like that for a move? That's called a threshold question. Sometimes judges, especially judges who know and understand constitutional law, will tell you plainly, sir, you have just raised a threshold question and this court lacks the capacity to move forward any further. We can't decide jurisdiction because you've raised the question of the prosecuting attorney. We can't move forward until your appeal to the state Supreme Court is completed as to whether or not you're going to have counsel who is unlicensed or licensed. You think I'm kidding? I'm not kidding a bit. This case that you're looking at right here has been bogged down for a year. What's the issue? Counsel. Do you know where the appeal is today? It's in the district court. It went from the traffic court to the district court, no further. The district court right now is trying to decide whether or not I'm going to have counsel to argue whether or not the jurisdiction of the traffic court is valid. Well, if nothing else, they've spent a year on a driver's license registration and proof of insurance, and in a year's time, the traffic court is unable to move. Now, if the district court never, forever, and I die at age 110, decides on this, I've won the case. The policeman gave me a ticket. I went into the court and I said, the court doesn't have jurisdiction, can't move. The court said, you've got a threshold question, appeal it to the district court. The district court is sitting on it, and I don't care if they ever decide whether or not I can have counsel in the traffic court to help me argue jurisdiction of that court in this case. They don't have any money. They don't have any property. They haven't put me in jail. They haven't achieved anything that they set out to do. I still don't have a driver's license. My car still doesn't have license plates, and the car still isn't insured. Now, who won? Me or they? You see how that's done? All right, now, let's assume that we can get beyond the jurisdiction question. And let's assume that we can get into a motion hearing. Do you begin to see what has happened here? Do you know I haven't been to trial in 2 years? I haven't been able to get out of the preliminary matters. A good competent pro se, once he gets some groundwork behind him and he gets some experience and he can stand in the court and he can speak and then he can take up an appeal. The moment I walk out of this courtroom, I go down and I write up an appeal and I file it with the district court, and that stops the lower court's procedure until the higher court has made a ruling. And even if they rule against me, I'll appeal it to the next one and the next one and the next one until I finally get the answer I want. Or let's suppose that the Supreme Court of the United States were to rule against me, and they said the lower court does rule correctly. You cannot have counsel to help you argue the jurisdiction issue. About 2 or 3 years from now, when the Supreme Court finally rules on that, I come back into Judge Curtis's court and I say, by golly, Judge, you're right on that point. I guess I don't get counsel to help me argue jurisdiction, so therefore I'll argue jurisdiction by myself in propria persona. And watch the judge rule against me and assume jurisdiction, and I'll say, hold it! I object! I can't move forward with this motion hearing until I get a definitive answer from the Supreme Court of the United States as to whether or not this court has jurisdiction. There's a major federal question here. Does a citizen have to have a driver's license to drive on the road? And can this court assume jurisdiction against the will and over the objection of a man who doesn't have a driver's license? I'll stipulate that the court has jurisdiction over all administrative matters. When a man comes in here licensed and volunteered into a regulated enterprise pursuant to Delaware versus Prowse and Almeida Sanchez and a number of other traffic cases, I'll stipulate to that. But, Your Honor, the major federal question in this case is whether or not an unlicensed driver can be compelled into this administrative process. And then I'll appeal that to the district court. And the district court will uphold Judge Curtis. And then I will appeal it to the appeals court. And the appeals court will uphold the district court of the 4th Judicial District. And then I will appeal that to the state Supreme Court. And they will uphold the appellate court's decision. And then I can argue my issue of whether or not a man who does not have a driver's license can be compelled into a foreign and alien jurisdiction called an administrative traffic court. And that's the major federal question. That's the threshold question. That's the threshold issue. And the Supreme Court of the United States, about 1989, will rule on that issue. Then let's suppose that the Supreme Court of the United States were to say, we affirm the decision of the traffic court judge. That court does have proper jurisdiction in this matter for this or that answer, or this or that reason. Then what happens? Now I come back to the traffic court, if Judge Curtis is still alive in 1989, and I say, Judge, you were right about that. By golly, I don't have the right to counsel, and you do have jurisdiction over me, whether I'm licensed or not. Your Honor, I am now ready to move forward with the motion hearing. See how important administrative and procedural matters can be to a good, competent pro se. You can run that train off the track as often as you want to. And I'll tell you what it does. It raises these major constitutional questions that your government officials don't want to answer, like grand juries, prosecuting attorneys, and informations and complaints. Whenever you have these processes, let's call them, for want of a better word, they're called administrative and procedural matters. It's just a matter of procedure to prosecute you by complaint. It's a matter of procedure to prosecute you by an information. I want to read to you here for a moment a case that came out of, now it's 117 U.S. 348, so it must have been around Civil War years. An information is a written accusation of a crime made by a U.S. attorney which permits the government to prosecute an individual without benefit of a grand jury indictment. An indictment was required in my case because I was charged with an infamous crime. The Supreme Court had clearly ruled in Macon versus United States, 117 U.S. 348, that any crime for which the punishment is imprisonment. Got that? Any crime which is punishment, which the punishment is imprisonment, is an infamous crime. The use of informations has a long history. For example, in the reign of Henry VII, writes Justice Blackstone, a very oppressive use was made of them for something more than a century, so as to continually harass the subject and shamefully enrich the crown. Also, as the court observed in People versus Sponsler, the oppressive use of this mode of prosecution by information occasions struggles to procure a declaration of its illegality. In short, prosecutions by information have long been a means of political suppression and intimidation. Well, friends, they're used today in Idaho just as a matter of course. And no one, it seems, objects to them. Informations and complaints. They put people in jail every day in violation of this Macon versus U.S. case, in violation of Hamlin Argersinger versus Hamlin, in violation of Supreme Court decision after decision after decision after decision after, how long can we go on? I have a book here of legal quotations. They must have 300 Supreme Court cases in here. I don't know of a single one of those. Well, I shouldn't say a single one. There's probably a half dozen or a dozen cases that the state of Idaho would recognize and obey. As a general rule, here in the state of Idaho, we don't even obey our own state constitution, and half the time, we don't even obey our own statutes. Our courts and our executive officers proceed against us as they damn well please, when they please, in any manner that they please, and there isn't anybody that's got enough knowledge to walk into the courtroom and say, hold it right there, troops. We have some administrative and procedural matters to take up before we move forward. You should be doing this, of course, in the arraignment. When the complaint's brought in here, hold it. Let me tell you a little story here and give you a little excitement. I went into an arraignment the other day, and there was a judge who looked just like our Judge Curtis. He's a man of 50, 60 years old, probably been on the bench for 20 years. And I'm charged with the crime of obstructing and delaying an officer in the performance of his duty. Well, all you have to do is go into a dictionary and look at the word obstructing. Now, what do you have to do to obstruct somebody? Don't you have to get in his way? Here's the officer, and he wants to go from where he is to here. Don't you have to get there? Stop him right there? Delay. Well, if you're going to delay him, he has to be moving at a certain rate of speed, or we have to have an anticipation of getting from here to there, or of accomplishing something. And don't you have to slow him down to delay him? All you got to do is look at the definition. So I walked into the courtroom. These are one of these dumb cases that my government brings against me to harass me because here in Ada County, Idaho, our government has too much money, and they don't have enough criminals. And so they have to invent crimes. These are called pretended crimes. These are officers sent out amongst us to eat out our substance. King George used to do that. We do that right here in Ada County. So they brought these charges against me, and I walked into the court and I said, well, wait a minute, Judge, I don't know how to plead to this, and I don't know, we're in arraignment now. I don't know whether I want to plead to this or not. Is this an indictable misdemeanor? Just take a look at a dictionary, friends. Indictable misdemeanor, crimes, indictments, and prosecution, get some definition. And this judge goes, well, see, he didn't want to admit that he was ignorant, didn't know what an indictable misdemeanor was. He fumbled around a little bit. He pulled out the Idaho Code, paused. About 3 minutes later, and when this happens, the silence gets deafening. Well, Mr. Gordon, it would appear that this is an ordinary misdemeanor. Did you want me to plead to an appearance, Your Honor, or did you want me to plead to a specific crime? Oh, well, see what happens when you ask somebody a question? I'm not really sure I want to plead to what appears to be. I want to plead to something that I know. Now, what I don't know is this an indictable misdemeanor or is it an ordinary misdemeanor? Now, I was pretty sure I knew what it was, but there's some confusion in the statute because here in Idaho, the legislature just revised it. And I'm not sure whether we could still call this an indictable misdemeanor or not. If it's indictable, then I want indictment. Get it! Don't sit here and ask me to give you permission, as you've got here. Look at this. An information is a written accusation of a crime made by a U.S. attorney which permits the government. I'm not giving you permission to do anything. Don't even want to be here. And he fumbled around a little more. Well, Mr. Gordon, it appears that this particular crime is punishable by a year in prison and a $1,000 fine instead of a year in prison and a $5,000 fine. Well, then it's not an ordinary misdemeanor. And if it's not an ordinary misdemeanor, it's indictable. And if it's indictable, then I demand a grand jury indictment. Fumbled around a little more. Well, Mr. Gordon, I think this is an ordinary misdemeanor. You think? Well, Okay, Your Honor, I can tell what's happening here. I'll tell you what I'm going to do. If this is an indictable misdemeanor, or any class of crime that is above and beyond an ordinary misdemeanor as prescribed by statute in Idaho, I stand mute and refuse to plead. The court has no jurisdiction. I demand all of my rights at law and waive none of my rights at any time. However, if this is an ordinary misdemeanor with a maximum penalty of $600 and $300 and 6 months in jail, then it would appear that this is a court of competent jurisdiction, and in that case, I want to plead not guilty. I think this is the first time I've ever pled in Idaho, to my knowledge. Well, maybe in the early days I pled not guilty a couple of times, but basically a person is not going to plead guilty or not guilty in a court. But, you know, if it's the court of original jurisdiction, you might as well plead because you're there. And, you know, it's superfluous and it's redundant and ridiculous to sit here in the district court, which is the court of original jurisdiction, and say, well, I challenge the jurisdiction of this court and you've just murdered somebody and here you are being brought in on a murder complaint with a grand jury indictment. I mean, there's, you know, common sense comes into play. Now, Judge, if you will stipulate and let the record show that if this is an ordinary misdemeanor and if the prosecutor over here does not amend this complaint in any way, then I'm going to enter a plea of not guilty and we'll proceed from there. Mr. Gordon, this is an ordinary misdemeanor and we're going to rule that this is an ordinary misdemeanor. And we're going to enter your plea of not guilty. He was so tickled that he got a not guilty plea out of George Gordon, he didn't know what to do with me. And that's a fact. And it was fun. I had a nice time. And as I tell people, if you're not having fun in the courtroom, you're not conducting it correctly. Now, another thing I wanted you to notice is, and I say this and I stress it very strongly, you must be in control of the courtroom. Did you notice how Mr. Cook, who is oftentimes called Mr. Gordon by Mr. Curtis, our judge, because he can't keep Cook and Gordon separated, but in that little scenario, did you notice that Cook or Gordon took charge, took control, and that every time the judge is trying to take control back away from Mr. Gordon, or Cook, whoever you want to call him, even I'm confused as to who I am now, that the defendant regains control and directs the operation and the direction of the court, that when the judge is trying to talk about motions, the defendant talks about administrative and procedural matters. When the judge shuts the defendant off, he loses his train of thought and says, well, I don't know, Judge, how'd you want to proceed? I thought you'd left it up to me to proceed. If you wanted to proceed, why did you ask me? See what you do? Now, it takes a little practice, and you've been trained in your government schools, and your government schools have taught you to be a sheep and taught you how to follow. You must learn and direct yourself to be a leader and not to accept the direction of somebody else. And you do that with knowledge. You have to have some knowledge behind you. You have to be able to pick up some legal quotations and say, this is the authority. This is the way it is. Judge Curtis, you do err not understanding the law. That's right. I've told that to numerous judges. Judge, you do err not understanding the law. Well, I get my law from the Supreme Court of the United States. I don't know where they get theirs. I think they get it from law school.